Hey everybody, this is Christopher Small with CMS Law Firm. We do estate planning, we do probate, we do it well. And I'm excited to have you here today to talk about, oh my goodness, I totally forgot what we were talking about. If you need to know all of your assets before you create an estate plan. If you have questions about that, you need an estate plan or anything else, and you want to talk, you can do it over the phone or in person. Just go to estatemeeting.com. You'll literally be able to see my entire calendar, pick a time that works for you, and talk to me. So go to estatemeeting.com. All right, let's talk about this question. I had a potential client meeting today, which is how most of these videos typically begin. And the people that called, it was a family. They knew that they needed to do an estate plan, but they were concerned because there was some issue about who owns what amount of what kind of a specific property. There's a potential that somebody owns all of it. There's a potential that they own like half of it, but they're not sure. And in some ways, this was slowing down their ability to get an estate plan done because they felt like they needed to figure that issue out before they did the estate plan. And that is probably something that's commonly thought. So I wanted to come out here and talk about it. The other thing too is, you may say like, oh, I've got a bank account over here, I got a bank account over there, I got an investment account over here, I got an investment account over there. I don't want to go track all this stuff down, so what I'm going to do is just not create an estate plan. Bad idea, okay? And not really completely necessary to do before you do your estate plan. The way that, unless, there's one caveat, but I'm going to tell you that at the end, I guess. When you're creating an estate plan, typically what you're going to say is, let's say you're married, okay? This is the easiest place to start. If you're married, what you're going to say is, I want all of my assets to go to my spouse, and then I want my assets split up evenly amongst my kids, if you have kids. You might also say, if you don't have kids, I want everything to go to my spouse, and then when they die, or if I die last, then I want X percent to go over here, I want X percent to go over there, X percent to go over here, that kind of thing. If that is the way that you want to distribute your assets, then you don't actually need to really know everything that you've got at the time you create your plan. The reason is if you die, then the person that you've named to be your personal representative, aka executor, is going to be in charge of tracking all that stuff down and then chopping it all up. So if you gave half over here and half over here in your will, it doesn't matter if you even know what that half is when you create your will, because when you die, it's going to get found out. Okay, so that's the first consideration to make. There is sort of one caveat, one exception, but the weird thing is if this applies, you probably know what the thing is, so you probably don't have this problem. If there's something specific that you want to give to someone, then of course you're going to have to know what that is so you can identify it in the will. So for example, if you knew you had a Bank of America account ending in 4277, hopefully someone listening to this has a Bank of America account ending in 4277, because that would be great. It would be ironical. Then what you're going to do is you're going to say in your will, I want to leave my bank account at Bank of America ending in 4277 with Joe Smith, for example, right? And if you don't have that asset identified in your own mind, then it's going to be impossible for you to identify that in your estate plan. Hopefully that makes sense. But on the flip side, if you know you want to give someone something specific, you probably are already going to know what that is. The other thing that you can do, if you don't know the account, you can also use a specific amount of money. You just want to make sure that you have a good idea of what your overall amount of money is, so that you don't give everything to one person and cut out other people that you would have wanted to give money to. For example, you could say at the top line, I want to give $100,000 to charity, and I want to split the rest amongst my kids. If your estate is only $80,000, then that $80K is going to go to the charity. The kids are going to get nothing if you set it up like that. Okay, so at the end of the day, bottom line is you don't necessarily need to know what all of your assets are specifically to create your estate plan. You don't have to have them identified specifically, because in your will you can chop, and in a trust too for that matter, you can chop them up according to percentages and then figure it out later. Okay, if you got a trust, by the way, one last thing, I don't just running off and do anything crazy. You are going to want to have some idea of where your accounts are and what those are, because after you create your trust, then you're going to want to fund the trust. by pointing those accounts to your trust. All right, that is it. As always, if this sparked some ideas, if it sparked more questions and you want to talk, you can do it with me for free, over the phone or in person. Just go to estatemeeting.com. Let's have a conversation. I'll learn about you and your family, and then we'll chat. So estatemeeting.com. Otherwise, as always, I am Christopher Small with CMS Law Firm. We do estate planning, we do probate, we do it well. Thank you for your time. If you like this video, hit the like button. If you know someone that needs to hear it, share it with them. If you have a question or comment, please leave it. If you're a podcast listener, subscribe and rate it, all the good things. And I will likely be here again to talk to you tomorrow. All right, have a great day, and I'll talk to you again soon.